Hello, my name is Eric Shine, Lieutenant Eric Shine. I'm a graduate of the United States Merchant Marine Academy at Kings Point. I graduated in 1991. I am here to give testimony regarding the status of the United States Merchant Marine, the United States Coast Guard, and the maritime industry as a whole, and pivotal incidents that have occurred since September 11, 2001, and since the launch of the war against Iraq or in Iraq in 2003. There have been some major changes in the maritime industry over the last 50 years. One of the most crucial issues that Congress needs to look into is the declarations by the United States Coast Guard that it is and has been since 1915 a quote-unquote special branch of the military. I oppose this contention, and I ask that Congress look to not only the United States Coast Guard and recent events, including the administrative law judges scandal that is going on, including Administrative Law Judge Jeffy Massey, and I believe the other individual is Rosemary Denson, and congressional testimony that was given to the subcommittee and also the committees involving not only the congressman, the chair of the subcommittee, Elijah Cummings, but other incidents, including the two vessels named the Bertolf and the Vosch, that are costing the United States taxpayers $750 million each, and also the tasks that have been assigned to the Coast Guard, and look more at some of the overarching issues regarding the United States Coast Guard and the United States Merchant Marine, and testimony recently by Admiral Thad Allen, and give due consideration and the opportunity to other individuals to appear before Congress regarding the United States Merchant Marine and maritime industry. My education is a several $100,000 education paid for by the U.S. taxpayer for a reason. I come out of Kings Point, which is a sister academy to the Coast Guard Academy, and I come out of there with a naval commission. In times of peace, I serve as a federal maritime officer embedded within the United States Merchant Marine and maritime industry, including shipyards and other critical strategic and economic assets that protect our country in times of peace and in times of war. The Coast Guard is not the only agency or department that has regulatory powers within the United States maritime industry. The U.S. Merchant Marine was set up specifically to govern American flag vessels, not only going overseas, but here within the United States. I ask that Congress look into the true status of if the U.S. Coast Guard is a branch of military. If it is, when did this occur? The Coast Guard is declaring that this happened in 1915 and that they have been a special branch of military ever since. But if you start to look into some of the evidence, the parole evidence surrounding this, and why the U.S. Coast Guard, if it has been a branch of military since 1915 or sometime since, why has it not had a court of criminal appeals for its own personnel? And I say that it is not a regular branch of military. It was not intended to be a regular branch of military. It is and has intended to be a branch of civil service, much like the police are in a state or locality or municipality, much like the FBI. And just because a service, a civil service, is uniformed and armed, it does not make it a branch of military. The U.S. Coast Guard is using language from the Military Commissions Act, the Warner Defense Authorization Bill, H.R. 1955 and H.R. 1959, to bring before it federal maritime officers, not just from deep sea, who serve in the United States Merchant Marine as valid federal maritime officers, but also as naval officers. Many of these individuals are commissioned naval officers like myself, and for a reason. This system was set up for this, or in this fashion, for a reason, and I ask that Congress delve deeper into this. I know that recently Congress has taken the matters regarding the ALJ system, which was initially set up for internal remedial systems of administrative process within the Coast Guard itself. The Administrative Procedure Act is a civil service law. The Coast Guard is taking something that was intended for its own personnel as a branch of civil service and has extended this over the entire United States Merchant Marine, that it is forbidden, even under the Administrative Procedure Act of 1946-47 itself, to get into any quote-unquote personnel or labor issues involving officers in the United States Merchant Marine. And I contend that these matters do not include just those officers like myself who have gone to Kings Point or any of the other maritime academies like Cal Maritime. Texas A&M has a maritime program. There are other ones in Mass and Maine. And it's not just those. There's also one in New York, which is part of the SUNY system, which is Fort Schuyler. Not just these state-run maritime academies, but even the federal institution that I went to, we are a separate and distinct branch of not only federal service, but oftentimes as formed as a naval auxiliary, so that in times of national catastrophe, like say Hurricane Katrina and the aftermath from that, that we can respond as civil servants, not as a branch of military. And then in times of war, our Naval Commission can be activated, and we can take over control of the vessel under the Department of Navy and under orders from the Department of Navy to get the vessel to a safe harbor or to protect the vessel and act as a liaison on board. These complex systems of civil defense and national security are being injured by most recent changes, structural changes within the United States Merchant Marine, within the United States Coast Guard, and within the maritime industry as a whole. And if you look to the two vessels, the Bertholf and the Vosch, these are for deep sea, which is, has been a purview or jurisdiction of the United States Navy for quite some time. The Coast Guard is no longer becoming the Coast Guard for the United States, but is pushing itself out into deep water, taking over roles that are normally carried on by the Navy. And one reason that the U.S. Coast Guard is usually on board for boarding parties with the U.S. Navy is the U.S. Navy is a regular branch of military, and it is not under posse comitatus, the U.S. Constitution, separation of powers doctrine. It is not to engage civilians, whether they be United States civilians or even foreigners, without a declaration of war. And that would be a declaration of war by Congress. Yet, the U.S. Coast Guard is saying that it is not only a special branch of military that can carry on military duties, but that it can also police or carry on law enforcement and not just cite, arrest, and detain and turn individuals over to civilian authorities like other branches of the military would do, but that they can somehow, within special military commissions or military tribunals, carry on adjudication of civilian law enforcement matters. And these are, make no doubt about it, these are military tribunals. These are military commissions. I have read the Military Commissions Act. I have read H.R. 1955 and 1959. I have read the Warner Defense Authorization Bill. And the language, especially from the Military Commissions Act, is being applied in here. I am and have been within a proceeding before the Department of Homeland Security, U.S. Coast Guard, even though I am not in the Coast Guard, even though I went to a sister academy to the Coast Guard Academy. I have been held and detained within these proceedings for the last 5 years on bogus, trumped-up charges, held without pay, without medical benefits, without legal aid. These are things that would be provided to the Coast Guard if they were in these proceedings. They are carrying these on these proceedings as summary, general, or special court-martials, not just of people like myself who went to Kings Point and who are in a separate and distinct branch of federal and even act as a naval auxiliary with our Naval Commission, but other individuals such as tugboat captains, ships captains, ferry boat captains, engineers, deckhands, all American civilian citizens here in the United States who are supposed to be protected by the Constitution, the Bill of Rights, due process, and more, and any and all rights or property that is to be taken from them is supposed to be done within the independent judiciary. What is going on now, though, is these individuals, unknown to themselves, are being brought before what is clearly military tribunals where individuals, and I will say names, Walter J. Brodzinski, who is an administrative law judge, he is a retired lieutenant commander from the U.S. Coast Guard, a pensioner, who is sitting as a hearing officer or ALJ within these military commissions, the prosecutor is a JAG officer from the U.S. Coast Guard wearing a uniform from what is declared by itself by the U.S. Coast Guard to be a branch of military that is acting as a uniformed military officer, a prosecutor of civilians. They are holding me within these proceedings and have for the last 5 years. They are prosecuting me, denying me rights to counsel, denying me due process. They are not even affording me the rights that would be allowed under the Uniform Code of Military Justice. First and foremost, though, I am a naval officer. I am not in the U.S. Coast Guard. They are using these military tribunals to go after other people who do not understand or recognize the proceedings that they are in, and that these are being carried out by officers within the United States Coast Guard who are self-declaring that they are a branch of military, who themselves come under the Uniform Code of Military Justice and for some time international law, the Geneva Conventions, the U.S. Constitution, posse comitatus, and other very strong bars against the U.S. Coast Guard from doing this, including case law like Reed versus Covert and other case law that has gone up to the U.S. Supreme Court, saying that the military is never supposed to have any control or authority over civilians except in extraordinary circumstances. These are not extraordinary circumstances. We still have our courts open. We still have civil law enforcement going on here in the United States. If anybody has broken the law on the water and the Coast Guard acts as the first responder, if they are truly a branch of military, then they are not supposed to arrest and detain and turn anyone over to civil law enforcement. The only thing that they can do is stop, hold on to the vessel until proper civil law enforcement individuals arrive, just like the U.S. Navy would do. But I contend that the U.S. Coast Guard is not, was not intended to be, and should not be a branch of military and allowed to carry on civil law enforcement. Presently, there are individuals from, this includes fishermen, who are coming before these military tribunals, unsure or unclear or unaware that these are military tribunals, that these are uniformed Coast Guard officers who are JAG officer, members of the Judge Advocate General Officer Corps. The Coast Guard Chief Administrative Law Judge, Enolia, is actually appointed by the Commandant. The command structure within these tribunals is enormously conflicted. I have endured them for the last 5 years, and I can tell you point blank that they are unconstitutional. And I ask that Congress look deeper into this, and not just the issues of the administrative law judge system or the two vessels, the Bertolf and the Vosh, but there are other issues surrounding the U.S. Coast Guard and how it treats its own people as opposed to officers in the Federal Maritime Service or the United States Merchant Marine, and including individuals who work in brown water or the lakes, rivers, and oceans here in the United States, or the fishing fleet or marine fisheries. I ask that Congress look deep into this because there are other issues that are arising, and we've had an incident here in California involving the San Francisco Bay Bridge and the Costco Busan. This individual, a ship's pilot, is being prosecuted now. And I understand that not only is Costco being sued, but many others. But the problem is not with the individual. If the system can allow a ship's captain or a pilot to run into a large piece of infrastructure, transportation infrastructure like this bridge, there's something wrong with the system to allow an individual to have that much control and that much power. We have learned lessons from the Exxon Valdez, where the Exxon up in Alaska now in Valdez, any vessels transiting their way into Valdez are escorted by tugboats. And when there's systems like this, the Bay Bridge in San Francisco or other bridges in and throughout San Francisco and other ports, there should be escorts by tugs who have their own radar systems so that if anything goes out on the vessel, whether the whole ship goes down and they have problems, temporarily in getting steering up, whether it be manual, emergency reserve systems, that the tugs can take over from the time that that vessel goes beyond the sea buoys and gets in, it should be escorted. Not only should the pilot be on board, but there's other systems that are involved in this shoreside that are supposed to monitor and watch the vessel and at some point respond. And if tugboats had been alongside, this incident would not have happened. There are other issues as to the boom ships and what happened to the boom ships as far as response. This is something that also came out from the Exxon Valdez 20 some odd years ago. And we had set up boom ships in all the port cities for rapid response. And at some point this failed. There are other issues that are arising, and the administrative law judge system is only one in a cornucopia of other issues. And one would be the Coast Guard last year tried a Coast Guard midshipman or cadet the very first time at any service academy. They tried him in a military tribunal. This has never occurred before in the United States at any of the institutions, whether it be West Point, Annapolis, Kings Point, the Air Force Academy, or Coast Guard Academy that I am aware of. And there may be few incidents, but as far as I know, this is the first time that any academy has prosecuted a cadet in times of peace or war within a military tribunal. There are also other incidences that Congress needs to look at deeper, like the issue of the Blackthorn, which is a Coast Guard vessel from 1980 that sank, killing, I believe it was 23 members on board. The Coast Guard captain of the vessel, did not face a court-martial due to this, which an officer in the United States Navy, if there was personnel killed, he would most likely face a court-martial regardless of how the incident played out and if he was held blameless, because at some point the captain bears all the burden. And in this incident, 23 individuals were killed. The individual did not face a court-martial. He got a letter of reprimand and was actually promoted thereafter. Yet, in the United States Merchant Marine, you have individuals like Coda, where there's been an oil spill, there is a serious issue, but it's the system that has failed and not the individual. And I ask that Congress look deeper into this so that this individual, I believe it's Captain Coda, does not end up like Campion or Ramos and railroaded into some kind of a plea bargain and put in jail for what has happened, where the system itself is at fault. And there's much more going on here. Not only the incident with the Coast Guard cadet, where he has actually been prosecuted in a military tribunal, this is about a year ago, but there's also been incidences of nooses at the Coast Guard Academy, similar to what happened in, I believe it was Jenna, Alabama, where the 6 nooses were put on the branch of the tree and various threats erupted, and I guess levels of racial, I don't want to say violence, but interaction. And we've even seen how there's been problems there with the court system, where the individual who prosecuted the black individuals who were involved in this incident, who responded to the nooses, were prosecuted, and the very same prosecutor and the very same judge were then the ones who heard the case in juvenile court. This gets into the issues of our judiciary, and this is evident within the administrative law judge system within the Coast Guard, where our court system is being turned in upon American citizens, and this is being used in an administrative, executive fashion to take away life, liberty, and property from U.S. citizens. Our Constitution was set up by our founding fathers to ensure that it was difficult and expensive to take away life, liberty, and property from any American. And I ask that Congress look into what is going on. If the U.S. Coast Guard is and has been the valid superintendent of the United States Merchant Marine, which I oppose, and I say no, it's actually the Maritime Administration and the Department of Transportation. If the U.S. Coast Guard is and wants to take claim to this as a branch of military, then Congress needs to take a close look at this, because when you do, you realize that there's a problem there where 97% of our U.S. cargo now coming into and leaving the United States is being carried on foreign flag vessels. And rather than correcting this and bringing much of this cargo back under the care and authority of officers in the United States Merchant Marine under American flag on American-built ships that are registered here in the United States, again under American flag, with U.S. crews on there, and officers who are trained at state maritime academies and at Kings Point, who are some of the best, brightest, and well-trained individuals in the world to protect not only our issues of pollution and our oceans, but also to get into using our own fleet. You know, if Congress wishes to believe that the issue of global warming is real, then take some action into bringing the fleet back under our control so that the regulatory schemes of the United States and our laws can be applied to this fleet and issues of pollution. You know, one of the biggest polluters in Los Angeles Harbor is the vessels there. They're basically floating factories. Under our scheme here as set up by Congress, and remember that United States officers in the United States Merchant Marine or federal maritime officers are considered wards under Admiralty and General Maritime Law to not only the courts because of so many laws being passed for us to protect us, but also to Congress as well for the same reason. And I ask that Congress begin to call in individuals such as myself and others and give us a fair hearing or a series of hearings so that we may tell you how we see things from our end and not hear things from the labor bosses, from the various labor maritime unions, not from the shipping companies, not from the federal employers, not from the port authorities, not from the port commissioners, not from the maritime academies, and not from the departments or agencies like the U.S. Coast Guard, but to hear from people on the deck plates who are working and have been working within the United States Merchant Marine and have faced many of the problems themselves, such as I have and many others. Gulf Coast Mariners Association is a focal point for many of these individuals, whether they be from the National Marine Fisheries, whether they be from the United States Coast Guard, whether they be from the United States Merchant Marine, whether they be from the other departments and agencies. And this is part of the problem with conflicts of interest, because there are many departments and agencies and corporations that employ federal maritime officers who have a vested interest in injuring our rights that are guaranteed by the U.S. Constitution and by the rule of law under General Maritime and Admiralty law, that are being stripped from us. Not only the Maritime Administration employs federal maritime officers, Military Sealift Command employs federal maritime officers, NOAA, the National Oceanographic Atmospheric Administration, employs federal maritime officers, Military Sealift Command, Naval Fleet Auxiliary Force, the Department of Agriculture. Almost all departments and agencies of the United States employ federal maritime officers, or are supposed to be employing federal maritime officers, to keep those jobs and the control of commerce, trade, and transportation under our control to a larger degree. At least if you go back to the Merchant Marine Act of 1920, the Jones Act, and the Merchant Marine Act of 1936 that established my academy at Kings Point, and actually study not only the laws, the legislation, and the language of the legislation, but to see the conditions that they were enacted within and look back to some of the congressional hearings in this regard and take testimony from individuals such as myself and take it seriously. I have prepared a statement to provide with this CD, and in the hopes that this will get into the hands of various congressmen and senators, not only on the subcommittee, but on the subcommittee for the Coast Guard and Marine Transportation, but also on the committee for surface transportation, and also other committees like the Judiciary, because there are issues that go over into and envelop almost all other issues, whether they be about civil defense or national security. And remember that the two are inseparable and intertwined. I have been attempting for the last 5 years to get to and before Congress and to get some of this information at least considered by Congress in open and fair hearings. And the U.S. Coast Guard, and I'm talking about high-ranking officials within the U.S. Coast Guard, including Admiral Thad Allen, who is the current U.S. Coast Guard Commandant, and also former U.S. Coast Guard Commandant Admiral Loy, who is now in charge of the TSA, which was the Transportation Safety Administration and has been converted to the Transportation Security Administration. There are many of these issues that go to the militarization of many things that should remain as a civil service if in the time of a declared war, whether it be by Congress or actions by Congress, that the Coast Guard, as a valid civil service in times of peace, would move under the Department of Navy as intended and come under the control of the Department of Navy in a declared war, just like the United States Merchant Marine. The United States Merchant Marine, when we come out with our Naval Commission, we serve as valid federal maritime officers. My time on board these vessels as a civil servant counts for employment as a naval officer and for my naval commission. When that is activated, then of course we also come under, in a declared war, the Department of Navy. Many of these issues are very serious, and I ask that Congress give them due consideration, and also to take a broader look, and not just at the administrative law system that has become a focal point for Congressman Cummings and others, but many of these other issues that revolve around the U.S. Coast Guard, the United States Merchant Marine, and the maritime industry, and that must be addressed to protect our country, not only in issues of civil defense, but also issues of national security. Thank you.